Hi, it's Sabu Kumliswa here. As you know that I've appealed for the ZIFA presidency that you're aware of. I have taken the necessary measures constitutionally, procedurally, to ensure that everything works accordingly. I can only do so much. I'm not a lawyer. I've left this in the hands of my trusted attorney, Sindo Ungwe, who belongs to the MD practitioners, Ungwe practitioners. In terms of what we have done, I cannot say much. Like I've said, at some point I have to stop. May I allow the legal gurus, I trust him as a legal guru in this constitution. Counsel, you understand the applications you have made from the appeal to the review. In a nutshell, what have we gone about to be able to get to where we are?
Okay, thank you. As the nation will be aware, there is an electoral process that is afoot that has been set rolling by the ZIFA Normalization Committee, and pursuant to that process, Sabu Kutemba Muliswa lodged his nomination papers to contest the vacant post of presidency. And subsequently, there was a vetting process that was done by the ZIFA Ethics Committee, which ruled that he was ineligible. The grounds or basis for that decision were communicated to us, and we have taken our time to consider the grounds that have been given, and to also consider the legal implications of the decision made, and to equally consider the legal recourse that is available to our client. And in consideration of those factors, we have observed two key issues. Firstly, that the decision made by the ZIFA Normalization Committee and the subcommittee that dealt with the vetting process is untenable and unsupportable in reason, on the basis that the disqualification criteria was that there was non-submission of O-level qualifications, yet the ZIFA statutes themselves speak of O-level qualifications or equivalent. Our client submitted qualifications which are clearly ranked above the O-level qualifications. That is the minimum threshold that has been set by the ZIFA statutes. So it is illogical and quite incomprehensible that you would be disqualified for holding a higher qualification than the minimum required. So on the basis of that, we have, in keeping with the provisions of the ZIFA statutes, lodged our appeal with the Court for Arbitration for Sports as mandated by the ZIFA statutes. That is the first issue. The second issue, in a normalization process, the ZIFA Normalization Committee has gone about normalizing ZIFA in an abnormal manner, in the sense that as a precursor to the electoral processes that are currently afoot, there was a constitutional amendment process, constitution making process that was championed by the Normalization Committee, and which, per the dictates of the mandate given to the Normalization Committee by FIFA, was to be ratified by ZIFA at Congress. As people may be aware, Congress was convened, I say convened in courts, on the 18th of October 2024, and thereat it presided over the business of ZIFA, and amongst other things, it resolved to adopt the draft amended ZIFA statutes, which were subsequently placed before the Sports and Recreation Commission and adopted by the Sports and Recreation Commission, and which is the basis upon which the current electoral process is currently being carried out. Now here is the crisis. The Congress of ZIFA can only lawfully make decisions, can only lawfully make resolutions if properly constituted. The delegates that sat on the 18th of October 2024 do not carry the mandate to carry out any football business on behalf of ZIFA. All the ZIFA councillors that were present and voting on the day had their terms of office expire as far back as October 2022. So from October 2022, none of those ZIFA councillors have carried a lawful mandate to transact any ZIFA business. So it follows, if the persons that set and determined and adopted the current ZIFA statute in 2024 had no mandate to do so, then it follows that that whole process is marred in irregularity. And if that process is marred in irregularity, the fruit of a poisonous tree cannot be anything other than poison. So what has followed pursuant to that constitution-making process is marred in illegality. So on the basis of the unprocedural process that was carried out in the constitution-making process, and on the basis of the unprocedural processes that subsequently followed, such as the electoral process that is currently underway, we have decided to take that matter up with our courts of law on review to determine whether or not the Constitution of ZIFA 2024, that is the ZIFA Statutes 2024, on the basis of which the current electoral processes are being carried out, was lawfully promulgated and lawfully brought into force. We beg to differ on that aspect. We believe that once you drink from a poisoned child, on the basis of the unprocedural processes that subsequently followed, such as the electoral process that is currently underway, we have decided to take that matter up with our courts of law on review to determine whether or not the Constitution of ZIFA 2024, that is the ZIFA Statutes 2024, on the basis of which the current electoral processes are being carried out, was lawfully promulgated and lawfully brought into force. We beg to differ on that aspect. We believe that once you drink from a poisoned chalice, you are taking in poison. Simple and straightforward. So that is the position. We've taken a two-pronged approach. We have, in the interim, appealed to the Court of Arbitration for Sport in terms of that particular ZIFA statute, but we also seek to impugn the same ZIFA statutes in terms of the laws of our land. That is the current status of affairs. Thank you.
Dicho, the law remains the law. Thank you.